Real property. Joint tenancies. Creation. The four unities are interest, time, title, and possession. Title must arise from the same instrument. The four unities for joint tenancies require tenants to acquire the same interest at the same time, with title arising from the same instrument for possession of the whole property. Destruction. Partition. Any joint tenancy may be partitioned by voluntary agreement or judicial action. Severance turns a joint tenancy into a tenancy in common, JT to TIC. There are four ways to do this. Give it away during life via conveyance. Sell it by signing a contract for sale. Lose it via actual foreclosure. Borrow against it, mortgage, in a title theory state. Co-tenants' rights and duties. Joint tenants, JTs, and tenants in common, TICs, have the following rights and duties. Possession of the whole property. Profits. A tenant may have to pay a co-tenant if they oust them, deplete natural resources which decrease the value of the land, or lease the land to a third party. Contribution. Each co-tenant must pay their fair share of taxes, mortgage payments, and for necessary repairs. Landlord-tenant. Tenancy in years can be week to week, month to month, or any other period of time. Tenancy in years. For any specified period of time which expires automatically at the end of the lease. Periodic tenancy. Has no fixed date and simply continues until one party gives valid notice. Must end at the end of a natural lease period, and valid notice is given at the end of one full period in advance. 1 month notice for a month-to-month lease. A tenancy at will continues until either party gives reasonable notice. Duties of landlord and tenant. Tenant must pay rent. If not, landlord may evict. Forcible entry and self-help are prohibited. Landlord may sue for damages, but should seek to mitigate. Tenant must not commit waste. Fact pattern will indicate what type of waste: voluntary, permissive, or ameliorating. Implied warranty of habitability. If landlord fails to deliver habitable premises, tenant may move out and terminate the lease, make repairs and offset the cost, remain and reduce or withhold rent, or sue for damages. Covenant of quiet enjoyment. Landlord must not evict tenant. Breach covenant of quiet enjoyment. Constructive eviction. Tenant must show that landlord has done or failed to do something which has made the premises uninhabitable or unusable, give notice to the landlord, and abandon the premises within a reasonable time. Assignment and sublease. General rule, unless otherwise agreed, an interest in a lease is transferable. Assignment. Transfer of remaining interest. New tenant is liable to landlord due to privity of estate. Old tenant is also liable due to privity of contract unless landlord allows a novation. Sublease. Transfer of less than remaining interest. New tenant is liable to old tenant, lack of privity of estate. Old tenant is liable to landlord, privity of contract. Non-assignment or sublease clause. Enforceable, however, courts will read these narrowly to find a waiver if possible, and if a landlord accepts rent payments from a new tenant, they are deemed to have waived the restriction. Real covenants. Non-possessory interest in the land obligating the holder to either do something or refrain from doing something to the land. Think real money. Plaintiff sues under a theory of breach of real covenant for damages. For benefit to run, only vertical privity is required. For burden to run, both horizontal and vertical privity are required. Privity. Horizontal between original parties, vertical between successive parties. Real covenants require privity, and privity includes intent, notice, touch, and concern. Intent, for the benefit to bind future successors, usually expressly stated. Notice, to the person who the covenant is being enforced against, usually record notice. Touch and concern simply means the use or enjoyment of the land. Equitable servitude. Think injunction. Plaintiff sues under a theory of breach of equitable servitude, seeking an injunction. Plaintiff needs intent, notice, and touch and concern above, does not require privity. Zoning. Typically, a city changes zoning and a pre-existing business is affected. Protection of pre-existing uses, non-conforming use. Many zoning ordinances protect or grandfather a pre-existing use. However, if the property is sold to a new purchaser, the pre-existing use is no longer protected. Variance. Waiver from a zoning regulation with a showing of unique hardship, potential harm to neighbors is considered. Nuisance. Public. Unreasonable interference with the health, safety, and property rights of the community. Private. Substantial and unreasonable interference with a person's use or enjoyment of their property. Easement. A non-possessory interest granting the right to use the land of another. Appurtenant normally runs with the land automatically. Transferee must have actual, inquiry, or record notice. Engross, personal use of land, are generally not transferable. Modernly, commercial engross easements are transferable. By prescription, hostile, open, actual, and continuous use of the land of another, like adverse possession. By necessity, land divided by one owner necessitates easement to access the otherwise inaccessible land. License, not an interest but a privilege to use another's land within the scope of the license. Land sale contract, adverse possession is hostile, open, adverse, and continuous, HOAC. Statute of fraud requirements, writing, parties, signed by party to be bound, describes land, states consideration. Marketable title, free and clear of all encumbrances, basically no one is going to sue you. Equitable conversion, once contract is signed, buyer owns the property. Remedy for breach of land sale contract, non-breaching party may sue for damages, difference between market price and contract price, specific performance, court orders defendant to perform. Right to lateral and subjacent support, adjacent soil, lateral, underlying soil, subjacent. Lateral support, right to lateral support is absolute. Natural state, landowner held strictly liable if excavation causes adjacent land to subside in its natural state. Improvements, held strictly liable only if shown that land would have subsided in its natural state, otherwise may be liable through negligence, requires negligence analysis from torts. Conveyance of deed, passes legal title from grantor to grantee when legally executed and properly delivered. Requirements, parties, in writing signed by grantor, description of property, words of intent, no consideration is required. 3 types of deeds. Quitclaim, conveys actual interest of grantor with no covenants of title. General warranty, warrants against all defects in title and the 6 present and future covenants below. Present, breached at time of sale, if at all. Season, grantor owns that which they purport to convey. Right to convey, grantor has the power to convey. Against encumbrances, no mortgages, liens, easements, or use restrictions. Future, warranty of title, grantor will defend any third-party lawful claim of title. Quiet enjoyment, grantee will not be disturbed in possession by lawful third-party claims of title. Further assurances, grantor shall do all which is reasonably necessary to perfect title. Special warranty deed, grantor promises they have not conveyed the property and it is free from encumbrances. Delivery of deed, requirements, intent of present transfer of deed, recording of deed, physical delivery of deed, which is also properly delivered. Rejection of the deed defeats delivery. Title passes immediately and is not revocable. Merger doctrine. Upon closing, the deed is the operative document governing the transaction. Unless a condition of the contract is in the deed, it is discharged. Damages awarded for breach of covenants if applicable. Defenses, unclean hands, latches, and waiver. Recording acts ensure buyer is obtaining good title. Common law rule, first in time, first in right. 3 types of recording acts. MBE terms below are found in MBE questions to confuse us. Race, first to record wins. No one uses this anymore. Notice, BFP prevails over non-recording grantee. BFP infers without notice. Quote, without notice thereof, unless the same be recorded according to law. That's an MBE term. Race notice. Subsequent BFP who records first wins over grantee who did not record first. Quote, without notice, who shall record first? MBE term. Recording acts protect BFPs and mortgagors. BFP takes for value and without notice. Recording acts don't protect donees, heirs, and devisees who do not take for value. Recording acts apply to every instrument which an interest in land can be created or modified. 3 types of notice. Actual, Buyer has actual subjective notice. Inquiry. A reasonable person could make further inquiry. Record. Constructive. Prior interest properly recorded within a chain of title. Exception. Wild deeds do not provide constructive notice as they are not recorded in such a way that a reasonable search would disclose.